Major breaking news out of New York City. A federal district court judge in the United States District Court for the Southern District of New York has just declared that major parts of New York City's licensing regime dealing with good moral character are unconstitutional under the Second Amendment and NYC versus Bruen, exactly as I predicted. We'll talk all about this when we get back, but this is exciting news. The Southern District of New York is no friend of the Second Amendment historically, and if we're getting big wins in the Southern District of New York, we're doing okay. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms, and obviously a lot of lessons in there that the Israelis should have learned about disarming their citizens, but we'll talk more about that down the road. All right, folks, this is exciting news. Major decision, federal district court judge, that's a federal trial judge, John P. Cronin, has just issued a 50-some-odd page opinion declaring that New York City's handgun and rifle licensing rules that says that you need to get a license first, but specifically the aspect of the licensing rules that says that you have to be a person of good moral character, and they can deny you if you are not a person of good moral character or for other cause. This is unconstitutional under the Second Amendment and NYC versus Bruen. Judge Cronin made it quite clear that this is not allowed. And he did an excellent job of analyzing the Second Amendment. Specifically, Judge Cronin pointed out to begin with, under Bruen, we start with the text of the Second Amendment. He said this is a no-brainer. The text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. The plaintiff here, Mr. Schroer, I hope I pronounced this right, S-R-O-U-R, Joseph Schroer, I apologize if I get that wrong, but Joseph Schroer sued New York City. In this case of Schroer versus New York City, and his argument was that he'd been denied a permit both for rifles and handguns for multiple times on the grounds that he had a history of speeding tickets and some arrests that had not given rise to convictions. And he said that is not a basis to deny his right to keep and bear arms. So Judge Cronin says, well, let's analyze this under Bruen. He starts off with the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. He says that because the plaintiff, Joseph Schroer, wants to possess rifles, shotguns, and handguns, those are obviously possession of arms. Thus, that speaks to the right to keep, which means to possess arms. So Judge Cronin says, undeniably, the text is implicated. And he says the way to understand this, and he did a nice job explaining this, that when you figure out whether or not the text is implicated by modern-day gun control law, you ask yourself, what is the conduct? What is the conduct that the Second Amendment plaintiff wants to engage in? In this case, Mr. Schroer wanted to possess handguns, rifles, and shotguns in his home, and obviously that's implicating the right to keep arms and the right to keep and bear arms. So at a textual level, the plaintiff satisfied the textual basis, which meant, and Judge Cronin got this totally right, he says, well, under Bruen, it's very simple. We know what happens. The answer is the burden shifts to the government to justify their modern-day gun control law. So in this case, the specific law they were trying to justify was a law that says that a city official, specifically a New York City NYPD, New York City Police Department official, had the authority under the law, the regulation, to deny someone the ability to get a permit to possess a firearm. If in the opinion of that New York City official, that NYPD official, the individual applying for a permit lacked good moral character, or otherwise there was a good reason or other good cause for denying him the ability to have this gun. Good moral character or other good cause is a basis for denying the individual the right to keep and bear arms. Well, the judge says, well, obviously, textually speaking, the Second Amendment is implicated. So that means the burden shifts to New York City to justify their law. And New York City failed utterly. Specifically, it's quite interesting. It's almost like this is embarrassing. I read the footnotes because sometimes the most interesting parts of opinions are in the footnotes because they're signaling something to someone in many instances with the court. So if you look at footnote number 6, and I'll put a link to this court opinion down below. Footnote number 6 on page 10 of the Schroer versus New York City decision from today's Judge Cronin's decision today basically makes it crystal clear that New York City's lawyers failed to appreciate that the burden is on them, that the old regime of they can just go wavy, and say, guns are bad, we're the police, we win. That was sufficient. Basically, the judge says that regime no longer exists. We respect the Constitution in the Southern District of New York now, and we respect the Second Amendment. And with that in mind, tell me if you think this footnote number 6 is a little bit of a spanking that Judge Cronin has given to New York City and to their counsel. This is what he writes in his footnote. In their briefing, defendants, which is New York City, in their briefing, defendants, New York City, at times seem not to appreciate that it is their burden. It is their burden to come forward with evidence that the challenged regulations are consistent with our country's historical tradition of firearms regulation. He goes on to quote parts of the arguments from the parties. Quote, notably, plaintiff's memorandum is devoid of citations to source material, statutes, historical analysis, or historical legal precedent to support the assertion that governments did not require individuals to seek permission to keep and bear arms. He goes on, the judge, citing again, I believe, to the plaintiff's briefs here, characterizing the defendant's arguments, or lack thereof. He goes on to say, quote, nor does plaintiff provide any historical analysis or contemporary statements regarding the ratification of the Second Amendment to support the conclusionary assertion that the challenged regulations are entirely inconsistent with this nation's traditional history of firearms regulation. And again, what the judge says as a reminder, Bruen was clear. Bruen was clear that this is, in fact, the defendant's burden. The defendant's burden. So basically, it's pretty clear that New York City came up with nothing, and there's no shock here. Because the other powerful thing that was discussed was something that Judge Kavanaugh said, which I had pointed out in this channel many months ago when we talked about some of the New York City things about good cause requirements and why not and why they're unconstitutional, because they embrace discretion. This is why I think trying to get people's mental health records, their medical records, any of these things is a no-go, because these things speak to the ability or requiring someone who works for the government to exercise some level of discretion to enter an opinion that you should or should not be able to have a gun. And that is inconsistent with what the Supreme Court said in Bruen, including a concurrence by Justice Kavanaugh and Justice Roberts. Specifically, if you remember what Justice Kavanaugh said, is as when he was basically saying, well, shall issue permitting regimes are okay if they're objective and narrowly framed. He goes on to say, and this is in Bruen itself, this is what Kavanaugh writes, he says that the 6 states, including New York, potentially affected by today's decision, may continue to require licenses for carrying handguns for self-defense so long, and this is the key, so long as those states employ objective licensing requirements like those issued by the 43 shall issue states. Bing, 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 bing. Bang. Exactly what I said. If you read the Bruen case and you also read the concurrence by Kavanaugh and Roberts, that standards for a shall issue permitting regime have to be objective. You get into wishy-washy stuff about someone's mental health or whether or not the doctor said yes or no, whether or not they have good moral character. Any of these things is starting to ask the courts, ask government officials like New York City officials, their opinion about whether or not someone should have a gun. This speaks directly to what Bruen says was unconstitutional, because the standard there was in New York City that was struck down. The may issue regime was the government decides, is this person deserving of a gun? Does this person need a gun, in our opinion? And the Supreme Court says, no, that's not allowed. It has to be objective standards. And that is exactly what Judge Cronin said here and why New York City failed to prove its burden. It goes on to say that the challenged firearms provision of New York City's here empower a New York City licensing official to decide not to issue a permit or license for a firearm based on that official's discretionary assessment of the applicant's good moral character and the determination of a vaguely defined presence of good cause. Judge Cronin goes on to say, in light of this, much like the proper cause inquiry invalidated in Bruen, permitting denial of a firearms license based on a government official's good moral character or good cause assessment has the effect of preventing law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. Bang! Southern District of New York, no friend to guns, no friend to conservatives. Guess what? Boom. Federal District Court judge says unconstitutional. Struck it down. Bye-bye. So what the judge said in his remedy is that those provisions are facially unconstitutional, and that is a no-go. So to summarize, major win out of New York. The judge is giving the city of New York a few days to come back as to how they want to handle this. Do they want to seek a stay of the order in front of Judge Cronin or go to the Second Circuit and seek a stay there? He basically wants to hear from the parties about what's going to happen and as to what they recommend happens next. But the bottom line is this is clearly the right decision. These rules in New York City were no good. They're discretionary licensing regimes, not allowed under NYSERPA versus Bruen, and it's great to see a federal court judge, a federal district court judge in New York City itself saying this is no-go, unconstitutional under the Second Amendment and under Bruen. Major win for the Second Amendment. We'll see what happens next in this case, but I think it's exciting news that we're starting to see Second Amendment victories in places that, frankly, a lot of us would not expect because of their history for being anti-gun. All right, folks. Hope you learned a little bit something here today. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.